On March 12th of 2025, Rex A. Heuermann, the suspected Long Island serial killer, was back in court. So today what we're going to do is just look at a brief summary of what happened in that courtroom, when the next hearing is, and then we're going to be deep diving a document which I found very interesting. And it's based on everything that's going on in the preparations for the trial. So let's quickly look at this. Then we'll read the document, and please know, buckle up, the document's 34 pages long. There's a lot of info in there. Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share. If you've never heard of this case before, or you've never seen my coverage of this case, please check out the description box. You can just click more, it'll expand it. There's a case background write-up for you, as well as a link to the playlist, and there you will find lots of deep dives, including a recent interview with District Attorney Ray Tierney. Now, I would recommend checking out that interview if you haven't yet, because he actually, obviously, I gave him unlimited time to speak. He could have been there for hours if he wanted to, if he had the time. And so he spoke a lot about this DNA evidence and technology and everything that they're going to be using and that they are preparing for the trial, right? So that was really great to hear. And I have linked that for you below as well.
That's what the science of STR is looking for. But because you're looking at those changes in sequence, you need a relatively large strand of DNA.
So here they say a pre-trial hearing to determine whether DNA evidence allegedly linking accused Gilgo Beach serial killer Rex A. Heuermann to multiple victims will be admissible at trial is scheduled to take place later this month, a Suffolk judge said Wednesday. Supreme Court Justice Timothy Mazzei set the first day of the Frye hearing for March 28th, so we can pencil that in our diaries, during a brief court conference in Riverhead. The prosecution and defense are both expected to call expert witnesses in the area of nuclear DNA testing. Now, normally when there's a court hearing, then afterwards, District Attorney Ray Tierney and the defense, Michael Brown, they will actually speak to the media, but it's not official press conferences, so we usually get all these little clips, you know. However, there's a YouTube channel called True Crime LI, for True Crime Long Island, and there they actually capture these, many press conferences in full. So go and check them out. I've linked them below as well, because it's very interesting to hear what District Attorney Ray Tierney had to say and what the defense attorney Michael Brown had to say about this court hearing, about the developments in this case. This is now obviously a summary that we're going over just in the interest of saving time, because that document's going to take us some time, okay? The Frye standard for admissibility of scientific evidence tests novel scientific evidence, like the DNA evidence that prosecutors want to use in their case against Heuermann, and requires that before being admitted, the prosecutor must prove the evidence's general acceptance by the scientific community, according to the Federal National Institute of Justice. If we were not confident, we would not have used it, Suffolk County District Attorney Ray Tierney said on Wednesday. Heuermann, 61, of Massapequa Park, has pleaded not guilty to murder charges in the killings of Melissa Barthélemy, Amber Lynn Costello, Megan Waterman, Maureen Brainerd Barnes, Jessica Taylor, Valerie Mack, and Sandra Costilla. Heuermann, who did not address the court but spoke directly to his attorney, wore a blue and white striped shirt, blazer, and maroon tie during his brief time in the courtroom. Tierney, speaking to reporters after the conference, said the investigation phase of the case against Heuermann is pretty much closed. Now that's interesting. Of course, the media is like, does that mean that you're not going to be connecting potentially any more victims to him? Do you not suspect him and any others? No. That's Ray Tierney answered with, well, if that's what you got from that, that's not what I said. It's just that now they obviously kind of have to wrap it up for this trial. I'm pretty sure more charges will be added later, just based on the little bit we know, just based on some of the other remains that were also found in the same area that could potentially be linked to this alleged serial killer. So pretty much closed. He said, we'll continue to look at those other murders, but we're not going to ascribe them to one person or the other until we can prove it. And we're not at that point of charging anyone for any of those murders, Tierney said when asked about the investigations into who killed the other known Gilgo Beach victims. Heuermann's defense team has asked the judge to bar the trial expert testimony on nuclear DNA results from rootless hairs found at 6 of the 7 crime scenes, arguing that the whole genome sequencing technique is not scientifically sound. So the defense is calling that magic, and then obviously the prosecution is like, it's not magic, this is science, okay, and this is what we're going with. The defense is doing their level best to obviously defend an alleged serial killer. That's a tough job, but I think there's the right defense attorney on this case for that job as well. The Suffolk County District Attorney's Office, in response to the defense motion, said the nuclear DNA evidence in the case against Heuermann should be admissible, citing in part that the results were corroborated by a second lab's mitochondrial DNA analysis. The defense has filed a motion seeking to have the case severed, arguing that prosecuting Heuermann for all the killings in a single trial could have a cumulative effect on the jury. Now, the response to that defense motion is the document we're going to read today, and that is very interesting. We've read lots of interesting documents in this case together, which is why I say go to the playlist and you can check it all out there. A lot of people still ask, well, how did they catch this guy after such a long time and all of that. If you don't know the timeline, we've literally gone and looked at every phase of Rex Heuermann's life, the suspect in these multiple, obviously, serial killings. We have looked at the investigative timeline, like how they caught him. We've read the PCA. We've read so many things. So just check out the playlist and you'll find it there, right? So the defense argued that the crimes have glaring and significant differences, citing differing injuries to the victim's remains. The only interest to be served in trying all the counts together would be that of judicial economy, but at the expense of Rex Heuermann's right to a fair trial, wrote Heuermann attorney Sabato Capone. Heuermann's attorneys have suggested the state go to trial first on the 3 women whose bodies were found at Gilgo Beach, Barthélemy, Costello, and Waterman, and then go to trial on the remaining counts related to the 4 other victims separately. And I would speculate 4 and a growing number eventually as time goes on. Newsday reported last month that prosecutors have said in court papers that Heuermann, this is what we're going to read in full now, Heuermann worked at Jones Beach for about 3 years when he was in his 20s. Again, we went over that in that whole timeline of every phase of Rex Heuermann's life, and we talked about him working at Jones Beach, but there's a little bit more detail here, so it's going to be interesting to read through that together. And so they said when he was in his 20s and became extremely familiar with Ocean Parkway at night, which was the burial site for 6 of the 7 victims. Notably, the investigation to date has established the defendant worked at Jones Beach from approximately 1981 to 1984, prosecutors said in court documents, which we were about to read. Newsday previously reported part of the defendant's work at the beach entailed the defendant getting on ATVs, all-terrain vehicle, and going from field to ensure that beachgoers were off the property once the beach was closed, a role that made the defendant extremely familiar with Ocean Parkway at night. I wonder what the recruitment process for that job was and why it was even there. If anyone knows, if you're local, please do let me know. I'm always interested to learn, all the local things. And there's often lots of locals in chat. So thank you so much for all the information that you send me as well. The judge is expected to rule on the severance issue in the coming weeks. What do you think is going to happen? I don't think the judge is going to sever the trials. I think he'll probably keep them all together because the state has done a really good job of arguing the point to do so. Now, are we ready? I've had a giant cup of coffee. Are we ready to dive into the newish, it's about 2 weeks old now, but 34-page document, new here. We haven't read it together and I just found it so interesting. So let's do that now. Now, thank you so much to Catch LISK, so Catch L-I-S-K, obviously L-I-S-K stands for Long Island Serial Killer, on X, because Catch LISK, Raul, sent me this document. I was looking for this and I'm like, this sounds incredibly interesting. So thank you so much, Raul, for sending me this so that I could read it to all the Grizzlies. Are we ready, guys? Okay, so Supreme Court, County of Suffolk, State of New York, the people of the State of New York, respondent against Rex A. Heuermann, petitioner, defendant. And you can see the date there was actually, it says return date 25th of Feb of 2025. Andrew Lee affirms this 25th day of February 2025 under the penalties of perjury under the laws of New York that the following is true and understands that this document may be filed in an action or proceeding in a court of law. Now, just so that you know what are you in for in case you think, oh no, this could be boring. It's not boring at all. I find it very, very interesting. We're going to hear about, obviously, his work at Jones Beach. We're going to see some of his, snippets from magazines and newspapers that he collected over the years. We're going to hear a little bit more about his Google searches, his HK planning document, and things like that. So I am an assistant district attorney in and for the County of Suffolk. I appear of counsel to Raymond A. Tierney, the district attorney of Suffolk County and attorney of record for the people of the state of New York. As such, I am fully familiar with the facts and circumstances of this case based upon the files maintained in the offices of the district attorney and my participation in the proceedings regarding this matter. The statements made herein are based upon personal knowledge and information and belief, the source of which are the files maintained by the Gilgo Homicide Task Force, conversations with witnesses, defendants' moving papers, and applicable statutory and case law. Now, first, I also want to say, I'll continue reading now, but what is this document about? It is about the defense asking for the trials to be severed, to have separate trials, as they just said, have one trial for the first 3 victims that were found on Gilgo Beach, and obviously connected to the suspected serial killer Rex A. Heuermann, and then to have another trial later or separate trials for the other victims, and this would be the state's response to that defense motion. Defendant Rex A. Heuermann is charged with 3 counts of murder in the first degree in violation of Penal Law 125/27 and 7 counts of murder in the second degree in violation of that code. The charges against defendants stem from a long-term investigation into a series of murders which occurred between 1993 and 2010. And I know I say this every time, but I still want to know what the hell Rex Heuermann did between 2010 and 2023, right? Like, what was he? That's just a complete gray area. Sorry if I tapped the mic and made a noise there. This investigation has culminated in the instant indictment, which charges the defendant with the murders of 7 women, including Sandra Costea, Valerie Mack, Jessica Taylor, Maureen Brainard Barnes, Melissa Barthélemy, Megan Waterman, and Amber Costello. If you want a breakdown of exactly when each victim was last seen, who they were, what happened, all of that so far that we know so far, that's also on the playlist. The investigation is ongoing. By motion dated January 21st of 2025, the defendant moves pursuant to criminal procedure law that the offences charged in counts 1 through 6 of the indictment number be tried separately from any trial of the offences charged in counts 7 through 10 of said indictment, and directing pursuant to criminal procedure law that the offences charged in counts 7 through 10 of the indictment, if you're only listening, I'm not reading out every single number, so I just say of the indictment number, each be tried separately from one and the other. Oh my goodness. In sum, the defendant demands 5 separate trials. 1 trial for Melissa Barthélemy, Megan Waterman, and Amber Costello, and then separate trials for Maureen Brainard Barnes, Jessica Taylor, Valerie Mack, and Sandra Costea, respectively. 5 separate trials. I don't know. Let me know what you think the judge will do. This affirmation and accompanying memorandum of law is submitted in opposition. So this is the state saying, we don't want that, judge, and here's why. And really, now we're on page 2 of 34, so 32 pages worth of data and evidence and everything to motivate why the state does not want that to happen. So as set forth herein and in our accompanying memorandum of law, the defendant's motion must be denied in its entirety, as all 10 counts are properly joined under criminal procedure law, as proof of each offence is material and admissible as evidence in chief of the other charged crimes. Therefore, separate trials are not authorized under, there's a code there. Moreover, even if this court were to determine that the counts are only joinable under CPL 222C, severance remains inappropriate as the victims are inextricably interwoven by geographic proximity, victimology, digital and physical evidence, forensic analysis, and the defendant's own planning document. If you haven't seen that document, then yeah, I'm going to say it again. You say it to the playlist because we went over that. In other words, the profit evidence set forth by the people for each victim is substantially the same with regard to each of the charged crimes, which establishes inter alia that 1. The defendant's identity as the perpetrator, 2. The defendant's specific intent and motive, i.e. to identify and hunt women for the purposes of committing murder, and 3. The complete narrative of events leading up to the defendant's arrest. Indeed, to date, the people anticipate well over 50 witnesses that significantly overlap with regard to each of the 7 victims. In addition, the people anticipate there are dozens of additional witnesses who may be called, many of whom also overlap among several victims. Accordingly, the prosecution would be unfairly prejudiced by having to present this volume of witnesses at 5 separate, lengthy, and costly trials. Of these witnesses, and as to each individually charged homicide, the people intend to present numerous expert witnesses in the fields of forensic science, telecommunications, and digital evidence. 5 separate trials would result in 5 separate challenges to the same evidence. Most importantly, granting the defendant's motion would lead to the unjust result of precluding the jury from hearing the full narrative of events necessary to comprehend the instant serial homicide prosecution. As a result, severance would not serve the ends of justice. Finally, to date, the people have provided well over 330,000 pages, and over 85 terabytes of data in discovery, which have been carefully categorized, organized, and cross-referenced to ensure that all materials are provided to the defendant not only in an organized fashion which will ensure a smooth and expedient trial, but also in a manner that seeks to lessen the amount of duplicate materials being provided. Notably, the discovery pertaining to each of the 7 victims is nearly complete. Therefore, there will be no delays attributable to discovery in scheduling a single trial that is inclusive of the 7 charged victims. Moreover, the scientific and forensic evidence in all charged murders is so inextricably interwoven that such evidence pertaining to one victim would necessarily be admissible as to each of the remaining 6 victims. A single trial will present a judicious and efficient use of time and taxpayer resources for all parties involved, i.e., this court and court staff, the people, and the defendant, whose defense is being funded by the county's assigned counsel defender plan. To the contrary, granting the defendant's motion and conducting any number of separate trials would be detrimental to all parties and precludes the jury from hearing the full narrative of events before making its determination, reduces judicial economy by requiring multiple witnesses to testify repeatedly before multiple juries. That's so exhausting, oh my word. And it would significantly prolong the process and expense incurred by the taxpayer, who will ultimately bear the costs associated with court staff, prosecutors, and defense counsel over the course of multiple trials. Justice and judicial economy require a single trial, especially where any alleged prejudice can be addressed by the court with simple and appropriate jury instructions. Now they talk about overlapping evidence. Although the charged murders were committed between 1993 and 2010, all 7 of the victims are connected via overlapping evidence and witnesses. So I really like the way they summarize everything in this document. We've read so many, and this is just a little bit of a different angle on things. It's nice to see it this way. So they say, example 1, physical and digital evidence connecting each of the victims to the defendant. 2, what has previously been referred to as the HK planning document, which unmistakably evinces the defendant's intent to each of the victims, both individually and collectively. Additionally, with regard to the homicides of most of the victims, there is further overlap with regard to 3, forensic attribution of hairs recovered from 6 of the 7 victims to the defendant and persons associated with the defendant. 4, murders for 6 of the 7 victims thus far occurring at times where the defendant had exclusive and uninterrupted use of his home, which provided defendant with unfettered time and opportunity to execute these crimes. 5, a central disposal site for 6 of the 7 victims, i.e. Ocean Parkway along Gilgo Beach. Accordingly, these matters were properly joined as substantially the same evidence and witnesses are necessary to prove each of the charges set forth in the indictment. So they do believe that he committed the murders at the home, from what I'm reading there. Physical evidence, oh, just in case, because there was still some speculation along the way of was it at the home or was it elsewhere, but more and more information has come out as time has gone on, and so it sounds like they're pretty confident that the murders occurred at the house. Physical evidence. Following the defendant's arrest and in the months thereafter, numerous search warrants were executed at the defendant's Massapequa Park residence. We were watching all of those and the press conferences and the drone footage and everything, and Manhattan-based architectural firm, which was on Fifth Avenue. A review of seized evidence reveals that the defendant kept publications relating to each of the 7 victims. Hence, all 7 victims are connected to the defendant on this basis. These publications include, so you know how movies would often, I mean, we've obviously studied serial killers along the way, but you know how movies portray like creepy serial killers cutting out little magazine snippets and making scrapbooks and things? Yeah, Rex Heuermann is innocent until proven guilty, but based on these little snippets, it's really the cliched serial killer. It's what one might expect from a serial killer, right? Just like, wow, you're collecting all of this, huh? So they said a Newsday publication issued on November 22nd of 1993, which referenced the homicide investigation of Sandra Costilla, see embedded images below. At the time, this publication was recovered from the basement of the defendant's residence. The publication was nearly 31 years old. So here you can see it says Long Island Briefs, body discovered in woods. The Suffolk County Police Homicide Squad is investigating the death of an unidentified young woman whose partially clothed body was discovered in a wooded area of North Sea on Saturday. 2 hunters discovered the body about 12:40 p.m. They called Southampton police, who notified the homicide squad. Police said that the body had been in the woods a few days and they suspect foul play. Police estimated that the woman was in her early 20s. The body was taken to the office of the Suffolk County Medical Examiner. Anyone having information regarding the case is asked to call the Suffolk County Police Homicide Squad at. So that's all public information, but wow, okay, there's one snippet. A New York Post newspaper issued on July 29th of 2003, which included an article entitled Serial Killer Eyed in Long Island Slay. See images below, they say. This article contained details surrounding the disappearance and murders of Valerie Mack and Jessica Taylor. At this time, this newspaper was recovered from what had been the defendant's bedroom. The publication was nearly 21 years old, so the writing is a bit small to read here, but I'm sure one could find it. And I'll make sure to post this document on Patreon as well, on the free tier, which is public. And then maybe you could zoom in if you wanted to. Hereinafter, spaces left intentionally blank, they say. Then, a New York magazine issued on June 6th of 2011 featuring a cover story entitled A Serial Killer on Long Island, see embedded images below, which discussed the serial murders of Maureen Brainard Barnes, Melissa Barthelemy, Megan Waterman, and Amber Costello, hereinafter the Gilgo Four. At this time, this magazine was recovered from the defendant's locked safe. The publication was over 12 years old. Oh my goodness, so it's like what they're recovering from his house all over the place. You can hear it didn't just collect this in one place in the house. It's all over the place. The bedroom, the basement, the safe. Then a People magazine issued on November 7th of 2016 featuring a cover story entitled Bodies on the Beach, Hunt for the Long Island Serial Killer. Who is the cold-blooded murderer killing women and dumping their bodies on a New York beach? Said article discussed the homicides of not only the Gilgo Four, but also that of Valerie Mack, who had been unidentified when the publication was released. At the time, this magazine was recovered from the defendant's Manhattan office, so it's like in the basement, in the bedroom, in the safe, this one in the office. The publication was almost 7 years old. Then the People assert that a jury can reasonably infer that defendant's possession of these items relating to each of the 7 victims were kept by the defendants as souvenirs or mementos or trophies of his crimes, serving as a reminder of the events that occurred throughout the murders of each victim, which is a common practice among serial sexual offenders. The prosecution intends to introduce this physical evidence at trial to prove the defendant's commission of the charged murders, as well as his intent and consciousness of guilt. However, in the event of separate trials, subject to that ruling, the people may be foreclosed from introducing such evidence at trial in this manner, which unfairly and unduly prejudices the prosecution. By the way, by me adding trophies, I know trophies would normally be like jewelry or locks of hair or something from the victim. So I'm not saying that these would be the trophies. It's just part of the collection. You know what I mean? That's why they say souvenirs or mementos. Wow. So they said, however, in the event of, okay, we read that one. So they said, introducing such evidence at trial in this manner, which unfairly and unduly prejudices the prosecution. That's where we were. In addition to these publications, law enforcement also seized other physical evidence. Example, serial killer publications, documents, burner phones, supplies, and electronic devices which similarly connect the defendant to each of the charged victims. And remember, we the public, we don't know, we only know a percentage of what's going on in this case and how much they really have, even though there's so much detail in these documents. So can you imagine how much evidence they have? So here they discuss again the HK planning document. As set forth above, law enforcement executed a number of search warrants at the defendant's residence, which culminated in the seizure of over 350 electronic devices. An analysis of a laptop computer recovered from the defendant's basement revealed a Microsoft Word document entitled HK 2002-04. The document was discovered in unallocated space. Unallocated space frequently contains room for new data or old data that has been deleted, sent to the recycle bin, overwritten, etc. For example, when a user deletes data, many users believe that the file has been purged forever. However, deleting a file only tells the computer that the space previously occupied by that file is now available. The deleted data will remain in unallocated space until another file is written over it. Data contained within unallocated space can be retrieved via a computer forensic extraction method called file carving. A forensic analysis of the HK 2002-04 document reveals that it was not only a locally created draft, i.e. not downloaded from the internet, but also recovered from a hard drive that indicates it was utilized by the defendant himself. That's also huge, and how they're going to prove that will be interesting, because I know a lot of people say, well, there were others in the house. What if it was his wife's document or like stepson's document, or, you know, people just like to blame everybody else in the house. But what if it was his, which they say they can prove? That's why I say that'll be interesting. Let's quickly read this footnote here. They said, in the event of separate trials, the people would still seek to introduce evidence of prior charged and uncharged acts for the limited purposes of establishing inter alia the defendant's intent, identity as the perpetrator, modus operandi, common scheme or plan across all victims, and absence of mistake. I.e., these murders were not committed as a result of an interaction gone wrong, but rather the defendant's specific intent was to murder these victims right from the very beginning. Therefore, the people submit the facts pertaining to each of the victims, and the defendant's commission of each charged crime would be admissible during the people's case in chief, regardless of whether severance is granted. If you're still with me, thank you so much. Make sure you hit the thumbs up if you haven't yet. I really appreciate you being here as we make our way through this quite lengthy but very interesting document, at least in my opinion. We're on page 10 out of 34. So here they say, we're going to continue. I just went up to read the footnote. Based on its original title, HK 2000-03, the original document appears to have been created in 2000, which notably coincides with the year that Valerie Mack was murdered. This iteration of the Word document titled HK 2002-04 appears to have been created and modified between 2001 and 2002. Moreover, the document itself references both past murders as well as plans for future murders, and therefore evinces this defendant's intent to identify multiple women for the specific purpose of murdering them, as alleged in the indictment. That is so eerie, so scary to think about. Based on the foregoing and the facts set forth in Frye, the people assert the Microsoft Word document to be a planning document utilized by Heuermann to methodically blueprint and plan out his kills, hereinafter referred to as HK planning document. The HK planning document begins with a 4-category section with the underlined headings of problems, supplies, DS, and TRG. See embedded image depicted on the following page. Now, we've gone over this a lot already, a few times, but if you just want to pause and read, you know, this horrifying HK planning document, it is quite something. So I'm going to continue here because we've gone over it before. As I say, just pause, check it out for yourself if it's the first time you're seeing it, and let's keep going. problems is alleged to be a self-apparent guide on how to avoid apprehension. For example, the document notes that leaving behind DNA, blood stains, fingerprints, tire marks, shoe prints, and hair and fiber are all problems to avoid, and doing so will likely lead to his apprehension. Additional problems contemplated by the defendant in the HK planning document include 1. Having an MO or modus operandi, as well as 2. Having to come up with misleaders, i.e. ways to confuse or mislead law enforcement. Hence, the people submit that any minor inconsistencies across the victims with regard to their, and they say this in quotes, dump sites, disposal sites, condition of the remains, etc., were carefully contemplated and intentional acts committed by the defendant, ultimately designed to confuse or mislead law enforcement into thinking more than one person was responsible for these murders. Let's look at the footnote here. A Latin phrase meaning mode of operating. Modus operandi refers to a method of operation or pattern of criminal behavior so distinctive that separate crimes or wrongful conduct may be recognized as the work of the same person. We continue here saying, point 17, supplies appears to be a reference to what supplies are needed to carry out the serial murders and to avoid apprehension. For example, for each of the 7 victims, some amalgamation of the listed supplies, example, rope or cord, saw or cutting tools, and bags or tape, were utilized across all 7 victims. Yet another fact that ties each of the victims together. You see why I like this summary? Because they're motivating why all these different victims need to be part of one trial. And I think they make a lot of sense. A jury can further reasonably infer the DS heading is an acronym for dump site, which is corroborated by inter alia the discoveries of Valerie Mack and Jessica Taylor at 2 separate, I would say, disposal sites. It's just, I don't know, more polite in my opinion. Dump site is always just, it just sounds so horrible, right? I.e. the vicinity of Mill Road and Gilgo Beach. The fact that this document was found in the defendant's possession and that both Valerie Mack and Jessica Taylor were found in the vicinity of Mill Road and at a second disposal site, i.e. Gilgo Beach, is compelling evidence that not only did the defendant kill Valerie and Jessica, but he also killed the other 4 victims whose remains were also found on Gilgo Beach. Under the same heading is a note regarding dumpster sites, which the people submit is a reference to how the defendant disposed of the physical evidence described below. Notably, all 7 victims were discovered without their personal effects. So this is dispose of the following tools and devices, T1 clothes and personal items, drop clothes or drop cloths, wipes and towels, and the rest we've already read before. So again, pause to read if you would like to do that. I wonder if he intentionally misspelled these words, you know, in case one day they find it or something. I know that was part of the speculation in the early days. So, TRG is believed to be an abbreviation for target or victim. Under this category, defendant includes the entry small is good, which is believed to be a reference to the physical preference in his targeted victims. Notably, all 7 of the joined victims were petite females who mostly weighed significantly less than 145 pounds and could therefore be easily transported and or overpowered in the event of resistance. So if this all sounds quite familiar to you, I mean, it should, but again, what I find different and interesting about this document is how they're tying this all together, which hasn't been done before, to say, well, this is the modus operandi, these are the similarities we see, and this is why we motivate this should be one trial. Now, the HK planning document on the defendant's laptop computer then delves into a 3-category section, and this is so scary, okay, with the headings of prep, and post-event. See embedded excerpt below. Just look at that. Oh my word. So he was allegedly, this is his document, that's what the allegation is, and just knowing all the planning that went into these serial murders is very scary, of course. So pre-prep refers to steps taken in advance of a homicide, i.e. inspecting his vehicle, engaging the target or victim, and conducting a recon or survey of where he could pick up a victim, pickup zone, or he says pick zone, without being seen on camera. For example, although Megan Waterman was captured on video surveillance leaving the Holiday Inn In Hopog, hope I said that right, before she disappeared and was murdered, the defendant took great care, as noted in his blueprint, to avoid picking up Miss Waterman right in front of or inside the hotel where video cameras would be expected to be present. This action, avoiding cameras that may capture his image or presence with Miss Waterman, evinces defendant's state of mind, his premeditated intent, formed well in advance of his encounter with the victim to capture and kill Miss Waterman. The prep heading refers to measures to take just prior to the murders. Listed in this section of the HK planning document are set up stage, holding area, build table, crossbar, and hard point. A crossbar is often placed underneath tables to provide further structural support for heavier objects being placed on a table. Similarly, hard point is a term used in sexual suspension bondage to refer to a fixed attachment point in the ceiling that supports the weight of an individual being suspended off the ground. These entries are consistent with the defendant's collection of pornography, where the subject is either suspended, tortured, bound to a table, decapitated, and/or their breasts are mutilated. This is also consistent with the injury sustained by multiple victims, as well as with evidence in the case that the defendant had such a hard point in his basement and did build multiple wooden tables, which are now missing and presumably destroyed. Post-event appears to reference a checklist of tasks following the event or homicide to avoid apprehension, i.e., destroy file, change tires, burn gloves, dispose of pics taken of the victim, and have story set. Example, alibi, story for family upon their return, or law enforcement should an inquiry be made. It bears repeating that the HK planning document was found in unallocated space, indicating the user, i.e. the defendant, attempted to destroy its existence. The HK planning document continues to further expound on preparatory measures such as specific recon steps. See recon reports and take down or pick up sections embedded on the following page. Packaging a body for transport. See body prep. That body prep section is also very scary. Section embedded on the following page, and steps to inhibit victim identification and avoid leaving behind DNA evidence. See body prep and dispose of the following sections embedded on the following page. I'm just going to insert a trigger warning here. This is obviously a case of a suspected serial killer who was alleged to be extremely violent. And so some of the information contained in this public record, this document, this part of this case, can be very distressing and upsetting to hear. So just know that, and if anything gets too much for you, just know we'll always save you a seat. You can always come back again whenever you're ready. So recon reports, we've gone over this before as well. That's why I want to make sure that we get through the document and I don't repeat too much, because I want to read you the new stuff, which is the summary of why these 7 murders should be part of one trial. So you can pause to read this if you've never seen it before. Sure, all these things, all these bullet points, huh? The body prep section of the HK planning document includes a guide on steps to take prior to packaging a body for transport. In said section, the defendant makes numerous references to torture, decapitation, and removing identifying marks on victims, which notably coincide to how the remains of several victims were found, i.e. Valerie Mack, decapitated, dismembered, and tattoo of her son's name cut off from her body. Jessica Taylor, decapitated, dismembered, and tattoo mutilated with a sharp object. And Sandra Costilla, sharp force injuries to her face, torso, breasts, left thigh, and vaginal area. It should be noted that due to the advanced skeletonization of the remains of the Gilgo Four, the medical examiner's office was not able to ascertain whether Miss Brainard Barnes, Miss Barthélemy, Miss Waterman, and Miss Costello suffered any similar mutilation or eradication of identifying marks. Notably, all 7 victims were indeed packaged for transport, another similarity that inextricably intertwines each of the victims and charges as set forth in the indictment. In the things to remember and take down or pick up sections, there are notes indicating steps to take next time, i.e. considering a hit to the face or neck next time. using heavier rope for the neck as the light rope broke under stress of being tightened, and recon for vidcams in pickup area next time. Wow, so they've highlighted that as well, the next time. As set forth above, it is clear the defendant was continuously refining his craft, or what he refers to as playtime. The HK planning document provides a window into the defendant's state of mind, evincing his clear intent for present murders, document initially created in 2000, i.e. Valerie Mack, and future murders, post-2000 homicides, i.e. Jessica Taylor, Maureen Brainard Barnes, Melissa Barthélemy, Megan Waterman, and Amber Costello, based upon issues that he encountered during his past murders, pre-2000, i.e. Sandra Costilla. This suggests a refinement in the defendant's technique over the series of murders and accounts for minor differences in packaging, location, and condition of the victims, as well as the defendant's clear intent to murder multiple women. The people assert that a jury can reasonably infer that these references to next time indicate Heuermann's prior experiences and his obsessive planning and premeditation, which necessarily resulted in changes to implement moving forward, inextricably tying the HK planning document to each of the 7 victims. Other digital evidence. We are now halfway through the document. In addition to the HK planning document, law enforcement secured other digital evidence linking the defendant to each of the 7 victims. For example, defendant utilized several fictitious email accounts to conduct hundreds of searches regarding the instant investigation and serial killers, not just in general, but also where serial killers rank. These searches include, but are not limited to, serial killers by state, 2023. Map of all known serial killers. Unsolved serial killer cases. America's 5 most notorious old cases. 11 currently active serial killers. 8 terrifying active serial killers we can't find. FBI active serial killers. So they're saying he researched this, right? Long Island serial killer, that was Long Island killer. Then Long Island serial killer update 2022. Remember, he was arrested in 2023. How cell phone tracking is increasingly being used to solve crimes. How does cell site analysis work? Historical cell site analysis, overview of principles and survey. FBI cellular analysis survey team. Gilgo News. New Discovery series tackles decade-old Long Island serial murders. In Long Island serial killer investigation, new phone technology may be key to break in case. Or I guess break the case, but it says to break in case. Cops launch Gilgo Beach homicide investigation task force. Yeah, and then they really got him. That special task force, oh my word, within months they were like, that guy, suspect number 1, right? Because they really paid attention to detail. It was actually so amazing to see. I started covering it when that special task force was formed. My channel only started in June of 2021. They formed the task force, and then they had these press conferences, and yeah, it just got so interesting from there. And they'd arrested him fairly quickly after that, inside the Long Island serial killer and Gilgo Beach. These are things that he searched, right? Based on the foregoing, a jury can reasonably infer that this inordinate number of covert searches regarding the very murders and resulting investigation that he is responsible for, a common practice among serial offenders and offenders in general, is indicative of the defendant's consciousness of guilt. Furthermore, a jury can reasonably infer the defendant's covert searches with regard to where he ranks in the pantheon of serial killers, also a common practice among serial offenders, is similarly probative of the defendant's guilt and his, wow, my voice is going. It better hold up, okay, because we're only halfway. And his clear intent to murder multiple victims. The people intend to proffer such evidence, which relates to each of the 7 victims, for the jury to make the ultimate determination. However, in the event of separate trials, the people may be foreclosed from introducing this evidence at trial in this manner, which is an unfairly and unduly prejudicial outcome to the prosecution, especially when an alleged prejudice can be addressed by simple and appropriate jury instructions. Again, trigger warning, this is very upsetting content that we're about to read of what he was researching and collecting and all of that, okay? Some of the words I actually won't be able to say on YouTube. I will just pause so that you can read it. The analysis of electronic devices attributable to the defendant has also revealed his collection of violent, bondage, and torture pornography, which currently dates back to 1994. The P images, I've got to try, oh my word, YouTube is not going to like this, include breast mutilation, vaginal torture, sex substitution, i.e. penetration of the victim's body with an object. Remember, I'm sharing this for educational purposes. This is a public record. It's a document that's part of a homicide case of an alleged serial killer that still is yet to go on trial. So the sexualization of decapitated women. Can you believe that sentence? Like, wait, what? Wow, okay. The sexualization of dismembered women, bondage and whipping. Again, this evidence is consistent with the marks and injuries suffered by each of the 7 victims. Moreover, the defendant utilized several fictitious email accounts to access and or conduct thousands of searches related to pornography, SA torture, and patronizing sex workers. For example, these discovered searches include, but are not limited to, and just look at those. Those I'm not going to read out loud. Just look at them. Based on the foregoing, and when taken in conjunction with not only the HK planning document but also the condition of the victims, a jury can reasonably infer that the defendant committed each of the charged homicides with the intent of fulfilling his own twisted and sadistic sexual gratification, yet another piece of evidence inextricably intertwined across the 7 victims. Unless otherwise notated, these searches are listed as they appeared verbatim in the Google record. So those ones, that's what they're saying, verbatim as they appeared. Uncle Google got him. Okay, just look at that. And as I say, not limited to this, or just snippets, previews of what he was looking at. And imagine how many they have. So these are just several examples where the terabytes of digital evidence against the defendant is substantially the same with regard to each of the charged crimes, which presents yet another strong indication that the charges are properly joined. And there's a code there. In that instance, separate trials are not authorized under another legal code. Then forensic evidence. We're on page 20 of 34. Another area of evidence overlapping between multiple victims is forensic evidence. First, the same laboratory, i.e. the Suffolk County Crime Lab, recovered and safeguarded the evidence from each of the crime scenes. In multiple instances, the same analyst recovered and processed key pieces of evidence involving multiple victims. Moreover, the same 2 outside labs conducted a forensic examination of hairs recovered from each of the 7 crime scenes. In each case, mitochondrial DNA testing was conducted by mitotyping technologies, and whole genome sequencing, WGS, DNA testing was performed by Astria Forensic. That's the one that the defense has a problem with. They're like, we don't like that one. Okay. In the case of 6 of the 7 victims, Sandra Costilla, Valerie Mack, Jessica Taylor, Maureen Brainard Barnes, Megan Waterman, and Amber Costello, the foregoing laboratories independently developed DNA profiles from hairs recovered from the victims that were later determined to be temporally, geographically, and personally associated with one individual, the defendant. At the trial, the people seek to introduce such evidence to establish the defendant's commission of the charged crimes or charged murders. To separate the trials, and thus this evidence, would be to drastically undercut the significance of this evidence. In that instance, instead of hearing the full picture, i.e. how hairs on 6 separate victims all point to one individual, which demonstrates the absence of mistake or mere coincidence, the jury could be misled into believing that a hair tied to the defendant ended up on a victim by mere happenstance. Should that occur, the resulting prejudice to the people's case cannot be overstated enough. There's a footnote there that says a reference chart annexed hereto as Exhibit A contains a summary of the analysis derived from said testing. We've also gone over that before. Then, additionally, even in the case of Melissa Barthélemy, the one victim without any probative hairs thus far attributable to the defendant, the absence of such evidence will be relevant to the defense. Accordingly, the forensic testimony from experts at mitotyping and Astria, as well as any other laboratories who conducted DNA sequencing, will be germane to all 7 charged victims. The prosecution intends to present witness testimony from representatives of each of the forensic laboratories who took part in the DNA sequencing and analysis. These witnesses will be presented as expert witnesses with travel expenses and witness fees incurred as a result. Any number of separate trials would result in multiple challenges to the same evidence, which is substantially the same with regard to each of the charged crimes. Additionally, the defense has already begun vigorously contesting the DNA evidence in this case in court, motion papers, and in the media. Yeah, in the media, literally calling it magic and junk science. This strategy will undoubtedly be redoubled during the trial of the above captioned matter, where the defense will cross-examine the people's forensic expert witnesses seeking to establish that the submitted hairs were either improperly recovered, maintained, and/or subjected to manipulation or contamination. The defense will further argue that the DNA analysis itself is arbitrary, inherently unreliable, and amounts to nothing more than magic. The people submit that this defense tactic would be applied whether it be one trial or multiple trials. That was so smart of the state to do that. To kind of say, well, we know they're going to do this because they're already doing it in the media, so why would we even need to have multiple trials? They're going to argue it anyway. Good point. In other words, even if the court were to grant the instant severance motion, the above stated defense arguments would open the door to the people proffering testimony that, notwithstanding these claims, the evidence shows that 9 hairs were recovered from the crime scenes of 6 separate murder victims between 11 and 28 years prior to the defendant ever having been identified as a suspect in this case. Those same 9 hairs were then tested and their DNA profiles were found to match either the DNA, so they say match in inverted commas like that, either the DNA profiles of the defendant or 3 individuals closely associated with the defendant, specifically and notably at or near the times the defendant actually resided with said individuals, allowing ample opportunity for their DNA in the form of shed hair to be transferred to the victims. Thus, the proposed severance would not save time and resources, as the same forensic evidence underlying each of the murders would be necessary to inter alia A, complete the narrative of facts which led to the defendant's arrest, indictment, and prosecution, and B, establish the defendant's identity as the perpetrator, and C, demonstrate the absence of mistake or mere coincidence. Accordingly, the charges are properly joined under those codes, and separate trials are not authorized. Now, modus operandi. This is page 22 of 34. In addition to the overlapping evidence described above, the victims each shared a common socioeconomic background, age range, gender, and unique physical characteristics. We've speculated this before, but now it's interesting to read it like this, that the state has outlined. As set forth in further detail below, each of the 7 victims are connected on that basis. Moreover, each of the victims' disappearance and murder occurred between the months of June and November, and thus far, in 6 of the 7 instances, occurred at times when the defendant had exclusive and uninterrupted use of his home. This shared victimology, timeline, and season of opportunity is another overlapping aspect of the defendant's modus operandi, which provided the defendant with a motive, means, and opportunity to commit the charged crimes. Accordingly, all 7 of the victims were properly joined in a single indictment pursuant to that code. Now they talk a little bit more about the victims. Sandra Costilla. On August 25th of 1965, Miss Sandra Costilla was born in Trinidad and Tobago. At just 7 years old, Miss Costilla was orphaned. In 1984, Sandra married an individual named Benjamin Costilla in Hawaii and subsequently moved to New York. In 1989, Miss Costilla gave birth to a son. During the course of the investigation, the Gilgo Homicide Task Force located a witness whose identity is known to law enforcement, who resided with Miss Costilla in 1993, just prior to her disappearance and murder. Based on a number of factors, said witness indicated his or her belief that Miss Costilla was a prostitute who frequented Manhattan. On November 15th of 1993, this individual drove Miss Costilla to work in Greenwich Village in New York City. Said witness believed that Miss Costilla was working at a print company in said area. Notably, the initial investigation revealed that Miss Costilla had not been employed at the company for over a year. After dropping Miss Costilla off for work, the witness never saw her again. 5 days later, on November 20th of 1993, Sandra Costilla's body was discovered in a wooded area of Southampton in the vicinity of 50 Old Fish Cove Road, North Sea, Suffolk County, New York. The victim was found lying on her back with her arms outstretched over her head and her uncovered legs spread apart. An examination of her remains revealed that Ms. Castilla suffered numerous sharp force injuries, including but not limited to her face, torso, left thigh, and vaginal area. In addition, her breasts appeared to have been mutilated with a sharp object. At the time of her disappearance and murder, Ms. Castilla was approximately 5 feet 2 inches tall and weighed between 125 and 145 pounds. She was just 28 years old and survived by her son, who was approximately 5 years old. Valerie Mack. Valerie Mack was born on June 2nd of 1976. Now, let me just quickly pause and say, in the interview that I conducted with District Attorney Ray Tierney, I was just thanking him for being so victim-centered, because we don't always see that, and even if DAs are victim-centered, they don't always communicate it in a way for the public to be able to read it like this. I mean, it's just, I know this is part of a legal document and they're motivating why they want the trials to be together, but I've just always found that this team is just, they bring the victims to life. They humanize them. They tell us a little bit more about them, and I just think it's really great. So Valerie Mack was born on June 2nd of 1976 in Atlantic City, New Jersey. Her birth name was Valerie Lynn Fulton. At an early age, Miss Mack was placed in foster care and shuffled between several foster homes until she was ultimately adopted by the Mack family. In 1994, at the age of 17, Miss Mack gave birth to a son and began living with her son's father in Wildwood, New Jersey. Shortly thereafter, she began frequently traveling to and from Wildwood, New Jersey to Philadelphia, Pennsylvania. In 1976, Valerie had her first contact with Pennsylvania law enforcement, resulting in the first of several prostitution-related arrests by the Philadelphia Police Department. Ms. Mack's final arrest came on June 25th of 2000. Based on the foregoing and the investigation to date, between 1996 and 2000, Ms. Mack is believed to have been working as a sex worker primarily in the Philadelphia, Pennsylvania, and Atlantic City, New Jersey areas. While she did advertise online, primarily under the alias of Melissa Taylor, Ms. Mack was also known to street walk, i.e. seek clients out on public streets. On November 19th of 2000, Valerie Mack's body was discovered by several hunters west of Halsey Manor Road and north of Mill Road in Manorville, New York. Ms. Mack's body was concealed within several black plastic bags, which were all wrapped with duct tape. Notably, the victim was decapitated and both of her hands were severed from her body. Her right leg was amputated at the mid-calf. Valerie's torso, legs, and arms were also bound with rope. A post-mortem examination revealed injuries to her left, mid, and lateral breast in the form of 2 contiguous ragged defects, which were likely the result of post-mortem mutilation with a sharp object. During the initial investigation in Manorville in 2000, Ms. Mack's head, hands, and right foot were not found at the scene, and their location remained unknown to law enforcement for approximately 11 years. On April 4th of 2011, as part of the expanded search of the Gilgo Beach area, Valerie Mack's skull, hands, and right foot were discovered along Ocean Parkway just east of Gilgo Beach, Suffolk County, New York. At the time of her disappearance and murder, Ms. Mack stood approximately 5 feet tall and weighed approximately 100 pounds. She was just 24 years old and survived by her son, whose name was tattooed near her right ankle. Jessica Taylor. Jessica Taylor was born on June 17th of 1983 in Poughkeepsie, New York. In 2003, Ms. Taylor was working as a sex worker primarily in the Washington, D.C. area. While she was based in Washington, D.C., Ms. Taylor would visit New York City frequently. During one of those visits, specifically on February 4th of 2003, Ms. Taylor was arrested for prostitution in Brooklyn, New York. In mid-July of 2003, Ms. Taylor hitchhiked from Maryland to Brooklyn, New York. Several witnesses indicate Ms. Taylor, while in Brooklyn, would take the train into Manhattan and work as a streetwalker, specifically in the Midtown Manhattan area. This area was near the defendant's architectural office. On July 21st of 2003, Ms. Taylor last utilized her cellular phone, which included a call to her mother, wherein Ms. Taylor arranged to visit her mother on July 25th of 2003 in Poughkeepsie, New York for her mother's birthday. On or about July 25th of 2003, when her daughter failed to arrive at her Poughkeepsie residence or answer any phone calls, Ms. Taylor's mother notified law enforcement. On July 26th of 2003, Jessica's body was found decapitated just west of Halsey Manor Road in Manorville, New York. She was found lying on her back with her legs spread and bent underneath her, approximately a half a mile from where Valerie Mack's body was recovered. Both of Jessica's arms had been severed from her body below her elbows. A post-mortem examination further revealed irregular disruption of her nipples and the obliteration of her tattoo by a sharp object. Her head, arms, and hands were not found at the scene in Manorville and remained unknown to law enforcement for approximately 8 years. On March 29th of 2011, Ms. Taylor's skull, hands, and forearm were discovered along Ocean Parkway, just east of Gilgo Beach, Suffolk County, New York. At the time of her disappearance and murder, Ms. Taylor stood approximately 5 feet 3 inches tall and weighed approximately 110 pounds. She was just 20 years old. Maureen Brainard Barnes. Maureen Brainard Barnes was born on June 14th of 1982 in Connecticut. Prior to her disappearance and murder, Ms. Brainard Barnes worked as an escort in Manhattan and advertised her services primarily under the alias of Marie on Craigslist, Backpage, and other websites. In practice, she traveled to Manhattan for a few days to work as an escort, stayed at a hotel, and then returned home to Connecticut. On or about July 6th of 2007, she arrived in Manhattan and stayed at a Super 8 motel located at 59 West 46th Street near the defendant's Midtown Architecture office. On July 9th of 2007, at 11:43 p.m., Ms. Brainard Barnes called a witness whose identity is known to law enforcement in Connecticut. Although she was known to work out of motel rooms, on the night of July 9th of 2007, Ms. Brainard Barnes told the witness that she would be going to meet a customer on a 1-hour out call. The victim further indicated that she would call the witness after the out call, which would assure said witness that Ms. Brainard Barnes was safe. Prior to getting off the phone, Ms. Brainard Barnes further indicated the outcall would be taking place in Long Island. When the witness did not hear back from Ms. Brainard Barnes, he or she reported the victim missing. There's a footnote which says an outcall is a visit to a client or John by an escort, i.e. at the location of the John's choice. On December 13th of 2010, Ms. Brainard Barnes' fully skeletonized remains were discovered on the north side of Ocean Parkway near Gilgo Beach. An examination of her body revealed that she had been restrained by 3 leather belts. At the time of her disappearance, Ms. Brainard Barnes stood approximately 4 feet 11 inches tall and weighed approximately 115 pounds. So you can start seeing the pattern, right? She was just 25 years old and survived by her 2 children. Melissa Barthelemy. Melissa Barthelemy was born on April 14th of 1985 in Buffalo, New York. She graduated from high school in 2003 and worked as a hairstylist. In 2008, Ms. Barthelemy moved to the Bronx. Prior to disappearance and murder, Ms. Barthelemy worked as an escort in New York City, primarily under the alias of Chloe, and advertised her services on Craigslist and other websites. On July 10th of 2009, just prior to her disappearance, Ms. Barthelemy called a fellow sex worker who worked primarily under the alias of Lisa, whose identity is known to law enforcement. During said conversation, Ms. Barthelemy advised Lisa that she had met a client off of Craigslist who promised her $1,000 in exchange for her services, an unusually large sum at the time. Lisa never heard from Ms. Barthelemy again. On December 11th of 2010, the skeletonized remains of Ms. Barthelemy were discovered along Ocean Parkway in Gilgo Beach, Suffolk County, New York. She was the first of 4 victims to be found that week. Ms. Barthelemy's body was wrapped in tape around her head, torso, and legs. A closer examination of said tape revealed clear indications of burlap material stuck to the adhesive side of said tape. At the time of her disappearance, Ms. Barthelemy stood approximately 4 feet 10 inches tall and weighed approximately 95 pounds. She was approximately 24 years old. Megan Waterman. We're on page 28 of 34. Megan Waterman was born on January 18th, 1988 in Maine. After being removed from their mother's care by Child Protective Services as a toddler, Ms. Waterman was raised by her grandmother. In 2005, Megan became pregnant and was sent to a home for young mothers. Her daughter was born in 2006. Shortly thereafter, Ms. Waterman met her pimp, whose identity is known to law enforcement, who frequently trafficked Ms. Waterman in New York for sex work. The The pimp advertised Megan on Backpage, Craigslist, and other related websites, commonly referred to Miss Waterman as Lexi. On June 6th of 2010, at approximately 1:30 a.m., Miss Waterman was last seen leaving the Holiday Inn in Hopog, Suffolk County, New York. Prior to her leaving the hotel, Miss Waterman spoke to a witness known to law enforcement and indicated that she was heading to an outcall with the same white male that she had met the day prior. Moreover, Miss Waterman indicated that this was the same John who had already given her $850 in exchange for her services, an unusually large sum at the time. Miss Waterman was never heard from again. On December 13th of 2010, the skeletonized remains of Miss Waterman were discovered along Ocean Parkway in Gilgo Beach, Suffolk County, New York. The victim was completely wrapped in a burlap-like material with tape wrapped around her neck and head area, about the waist area and lower legs. A paper towel was recovered from the victim's mouth. Oh my goodness. On June 8th of 2010, Miss Waterman was reported missing by her mother and grandmother. At the time of Megan's disappearance, she stood approximately 5 feet 5 inches tall and weighed approximately 115 pounds. Miss Waterman was just 22 years old and survived by her daughter. Amber Costello. Amber Lynn Costello was born on February 10th of 1983 in North Carolina. At a young age, Miss Costello was the victim of sexual abuse. Later in life, she struggled with substance abuse and addiction. In 2010, Amber moved from Florida to Long Island. Upon her arrival in New York, she attended a 28-day rehab program at St. Charles's Hospital in Port Jefferson for drug addiction. However, soon thereafter, Amber relapsed and began to work as an escort. Prior to her disappearance and murder, Miss Costello worked as an escort primarily in Long Island under the alias of Carolina and advertised her services on Craigslist and other websites. On September 2nd of 2010, at approximately 12:05 a.m., witnesses described how Miss Costello and others executed a ruse on a John who entered Miss Costello's home, paid for her services, but was encountered by a person who pretended to be the outraged boyfriend of Miss Costello. The John then left while Miss Costello and others kept the client's money. Based upon interviews, this John was described as a large white male, approximately 6'4" to 6'6" tall, in his mid-40s with dark bushy hair and big oval-style 1970s type eyeglasses. Furthermore, based upon his height and thick build, the client was described as appearing like an ogre who drove a first-generation Chevrolet Avalanche. That was so key to tracking down the suspect. The foregoing description mirrors the physical attributes of the defendant, who was 46 years old, approximately 6'4", weighed well in excess of 240 pounds, with dark bushy hair and large eyeglasses, and drove a 2002 first-generation Chevrolet Avalanche at the time of Miss Costello's disappearance and murder. See embedded photograph below, taken on September 15th, 2009 by the New York State Department of Motor Vehicles. Oh, DMV picture. Okay. Later that same day, Miss Costello was again contacted by the same client that was the subject of the ruse. Miss Costello told her roommates that the client wanted to see her again, but he didn't want to come back to the house given what had happened the night before. Furthermore, Miss Costello indicated her willingness to go on the date as the John promised an unusually large sum of money in exchange for her services that night. On September 2nd of 2010, at approximately 11:20 p.m., Amber Costello left her home. Shortly after Amber left the house, a witness observed a dark-colored truck. Once again, a Chevrolet Avalanche passed the house, specifically coming from the direction Amber had walked towards. Witnesses indicate they never saw Miss Costello again. On December 13th of 2010, the victim's partially skeletonized remains were found near the remains of Melissa Barthélemy, Megan Waterman, Maureen Brainard Barnes, near Ocean Parkway in Gilgo Beach. Her body was wrapped in burlap with tape around her neck, hip, and ankle. A folded shirt was recovered from inside of the victim's oral cavity. A folded shirt, oh my goodness. At the time of her disappearance, Miss Costello stood approximately 5 feet tall and weighed approximately 100 pounds. She was 27 years old. Here, the defendant's choice of victims is one aspect of his modus operandi. Each victim included in the indictment shares the same gender, age range all in their 20s, and physical characteristics, young, petite women, with most weighing significantly less than 145 pounds. Moreover, each of the victims were either known sex workers or described to be sex workers and shared the same socioeconomic standing, which made them particularly vulnerable. All 7 women are connected on these bases. The physical preference is probative of identity, since these qualities enabled the defendant to gain easy access to the victims and overpower them, as well as a window of time to evade detection, i.e. between the time they went missing and when their bodies were identified. Since targeting young female sex workers who struggled financially is unique to this pattern of crimes, it is indicative of an overarching modus operandi, and therefore the charge contained in the indictment are properly joined. So the charges, exclusive use of Massapequa Park home. Moreover, in the case of 6 of the 7 victims, the overarching modus operandi thus far includes the disappearance and murders of each victim occurring at times when the defendant had exclusive and uninterrupted use of his home. At trial, the people intend to proffer witnesses, testimony, and documentary evidence that will be substantially the same, as it will establish in each instance the defendant had unfettered time and opportunity to execute all these crimes. Just need to drink some water, hold on. Additionally, both mitotyping technologies and Astria independently developed DNA profiles from hairs recovered on 6 of the 7 victims that were later determined to be temporally, geographically, and personally associated with the defendant. The timelines of witness 3, Asa Ellerup and Victoria Heuermann's cohabitation with the defendant, all indicate that these crimes were committed when there was no risk that these 3 individuals would come home and bear witness to the defendant's acts. In each instance, the association of Asa Ellerup, Victoria Heuermann, and witness 3 to the defendant matched the timelines of the victim's disappearance. Defendant's uninterrupted use of his Massapequa Park home during each of the disappearances is inextricably interwoven into the narrative of events and demonstrates both intent and opportunity to commit each of the charged crimes. Then, central disposal site. Finally, 6 of the 7 victims were discovered in whole or in part at a central disposal site, i.e. Ocean Parkway along Gilgo Beach. See embedded map below. And they've actually got a chart here if you want to pause to read. We've done lots of map time before as well. And of course, Catch LISK is a really great map, like really comprehensive if you've never seen it before. I think it's pinned on his X profile, which is linked in the description box below. So then here's a footnote. Witness 3, as referred to in prior filings, is an individual whose identity is known to law enforcement, who resided with the defendant from 1990 to 1993. That was his first wife. An arrangement which ended just months before the disappearance and murder of Sandra Costilla. So if that was the first murder that he allegedly committed, it would have happened soon after he divorced his first wife, or that she divorced him. Okay. This makes it likely that there was ample opportunity for witness 3's DNA once again in the form of shed hair to be transferred to Miss Costilla. Notably, the investigation to date has established the defendant worked at Jones Beach, remember we read about this earlier, from approximately 1981 to 1984. Part of the defendant's work at the beach entailed the defendant getting on all-terrain vehicle and going from field to field to ensure beachgoers were off the property once the beach was closed, a role that made the defendant extremely familiar with Ocean Parkway at night. This evidence of defendant's connection to the shared burial site of 6 of the 7 victims is another overlapping aspect of the defendant's modus operandi, which provided the defendant with a motive, means, and opportunity to commit the charged crimes. Accordingly, the victims are properly joined in a single indictment pursuant to those codes, and therefore separate trials are not authorized under that legal code. Defendant's motion should be denied in its entirety. To be clear, this is nowhere near an exhaustive list of overlapping evidence across victims. Can you imagine? That's what I say. Nowhere near. For example, there is significant telephone analysis that will be substantially the same as it pertains to the Jessica Taylor, Maureen Brainard Barnes, Melissa Barthélemy, Megan Waterman, and Amber Costello, which will help establish inter alia the timeline surrounding each victim's disappearance and murder, their encounters with the defendant, the areas in which the use of the burner phones frequented, i.e. Massapequa Park and Midtown Manhattan, and how said areas comport perfectly with where the defendant frequented as established by inter alia financial and telephone records. Moreover, there will be evidence set forth regarding the defendant's ties and familiarity with the Manaville area. Interesting. From hunting, right? We looked at that before, which is where both Valerie Mack and Jessica Taylor were discovered. There will be evidence set forth regarding the defendant's ties to the Southampton area, which is where Sandra Castillo was discovered. Here, the defendant has not established his entitlement to 5 separate trials. For the reasons set forth herein and in the accompanying memorandum, all counts are properly joined under those codes. Therefore, separate trials are not authorized under more legal codes. Moreover, even if this court were to determine that the counts are joinable under a certain code, severance remains inappropriate as the victims are inextricably interwoven by geographic proximity, victimology, digital and physical evidence recovered, forensic analysis, and the defendant's own planning document. As set forth above, the people anticipate well over 50 possible witnesses that will overlap with regard to each of the 7 victims. Accordingly, the prosecution would be unfairly prejudiced by having to present this volume of witnesses at 5 separate trials, lengthy and costly trials. Most importantly, granting the defendant's motion would lead to the unjust result of precluding the jury from hearing the full narrative of events necessary to comprehend the instant serial homicide prosecution. As a result, severance is not only unnecessary, but it would also not serve the ends of justice, especially as any alleged prejudice can be addressed by an appropriate jury instruction. Wherefore, as set forth herein and supported by the accompanying memorandum of law, the defendant's motion should be denied in its entirety. And you can see that Raymond A. Tierney, District Attorney of Suffolk County, it says by, here's a signature from Andrew Lee, Assistant District Attorney, dated February 25th of 2025. Now, if you made it to the end of this video, please comment that so that I know that you watched till the very end. That would be very interesting to see. I know not many people make it to the end, but I know many of you in this community love documents the same way I do. You love information and detailed information. And I mean, this investigation is absolutely massive. This case where they caught the suspected Long Island serial killer, oh my goodness. I mean, that was years in the making. And I'm so glad that they were able to do that with a special task force that was formed. And I'm interested to see when the trial date will be. And, you know, I don't know if we'll be able to see it. Based on my questions to District Attorney Ray Tierney, it sounded like New York doesn't normally have cameras in the courtroom. And I'm like, please, can we please have cameras in the courtroom, sir? Didn't sound like, based on his answers, that would be a thing that they would want. But man, I would love to see this trial. I would love to watch the trial with you and just see. I think it's a really brilliant prosecuting team. And I think there's also a really strong defense team. So it will be so interesting as well. Anyway, thank you so much. I guess I've used my voice enough today. If you like the way that I present true crime, please hit the like button, share as well, whether it's to Facebook or X or Reddit or Blue Sky or with a friend or on email. It doesn't matter. It always helps tell YouTube that yes, show this to more people. It also helps tell me that yes, you like the deep dives on this case that I'm doing. I actually recently received an email from a reporter, which was so sweet. And he's the managing editor of Dan's Papers based on Long Island, New York. And he said he's the former digital editor of the Long Island Press. And he said, I just wanted to reach out to commend you for the wonderful work you've done in your podcast on the Gilgo Beach case. And I appreciate how you've used my articles in your podcast from time to time. Of course, as I always say to you guys, I'm not a podcaster, I'm a YouTuber. But I mean, I so appreciate the words and the sentiment. And he said, I never miss a Gilgo related episode of Grizzly True Crime. I particularly enjoyed your conversation with District Attorney Ray Tierney and found it very informative. I believe some small hints may have been dropped in that interview as well. Hence, we the press are unable to extract generally, right? There were some interesting little bits of information there, right? And so go and check it out. If you haven't yet, go watch it next. Go check out the playlist, do a deep dive. I think one needs to keep an eye on this case because before we know it, it's absolutely Mount Everest worth of information. So I always try to see when is there a press conference, when's the next court date, you know, and I mean, obviously Catch LISK Raul is also keeping a very, very close eye on this case. So thank you so much everyone for watching, and I appreciate you being here till the very end. I really enjoyed reading a little bit more about each of these victims and how they are tying all these cases together. I find it interesting. Let me know if you also find it interesting, and I will see you in the next one. Stay safe.